What is her name?
Brooks.
First name?
Darrell.
Hello and welcome back to Mushmouth Joe. So I'm revisiting the Darrell Brooks case again. I'm recording this audio on Saturday, August 30th. And earlier this morning I saw this article on the Freeman, which is a local Waukesha County newspaper. And according to them, Darrell Brooks has submitted yet another extension. But apparently it wasn't delivered until yesterday or Friday. And we all know that it was due on the 27th, which was Wednesday. But I imagine since he was sending it from South Dakota, they probably won't call foul and they'll just grant him the extension. That's my opinion anyway. And who knows, by the time I upload this video, it may already be common knowledge. But since we don't have any word on his actual appeal, or whether or not this new request for extension has even been granted, I thought it might be fun to speculate on what the basis of his appeal might actually be. And I think by looking at some of the earlier pretrial footage, you can see a lot of clues as to what that basis might be. So this footage comes from March 11th of 2022, when Brooks still had counsel. It might even be the first time he appeared before Judge Doro.
As the parties are aware, the state filed a letter on the 7th advising the court or wanting to make the court aware that I had some familiarity with the father of victim C. Victim C is one of the homicide victims, and under the statute, the father of a deceased is also a victim. So I felt it prudent to seal that letter to myself be in compliance with Marcy's law. As everyone is aware, that is a requirement that applies not just to the state when they file documents, but to the courts, the parties, etc. And so I did have that sealed, but I also ordered it redacted so that a redacted version could be made part of the public record. And it's my understanding that has been done.
So I think it's important to note here that this information was brought forward by the state prosecution, not by the defense. And the reason for doing so most likely is because they want to dot all their I's and cross all their T's. And they don't want the defense team or Darrell Brooks to be able to use that against them, which is the whole reason for this conversation. But you may have also noticed that Darrell Brooks blurted this information out in front of the jury. And I don't remember which day that was from. I just remember him talking about it. But I do remember that it was during one of his loud outbursts that he had every day in the trial. And I highly doubt that any of his outbursts were included into the record. But even if he can use this as basis for an appeal, they've already defeated it here in the pretrial.
I wanted to make some disclosures out of an abundance of caution and as encouraged in the comments to Supreme Court Rule 60.04 sub 4, which talks about notification of information on the record to the parties when that information might be considered by the parties relevant to the question of recusal. First and foremost, this court believes it absolutely can and will be fair and impartial to both sides in this case. Here are the facts, though, that I want the parties to be aware. The court is familiar with the father of victim C and his wife. I am familiar with the father because I worked in private practice from September of 2005 through the end of 2011. I worked in a law firm that was located in the Seatman Realty building. And for those in Waukesha know that's on the corner of I-94 and Pewaukee Road. There are a number of law offices in that building, and the father of victim C had a law office as well. I was not formally affiliated with him, and at times his wife would work there as well. So that is how I know the father of victim C. We were in the same building, but again, not officially affiliated. I did have this person, the father of victim C, do some estate planning for my husband and I back in 2012. Our will, trust, things of that nature were finalized in March of 2012. We paid for that legal work. It was not free. In addition, the attorney, the father of victim C, also did some business work for my husband, some work related to the formation of a business in 2015. Now, we have since transitioned to a different firm and a different lawyer, and it's also my understanding that he is now retired. Again, we paid for that legal work. It was not free. The last time the court communicated with the father on any legal matters was in 2018, when I asked him a question about the business formation by email, and some related work, potential work related to putting a home that we had in a different name. Again, that did not result in any work being done. He did respond by email. I also want the parties to know that on February 8 of 2012, this attorney did make a contribution to my Jennifer Doro for judge. As most people in the courthouse are aware, I was appointed at the end of 2011, took the bench in 2012, and this person made a contribution in the amount of $500 on that date. Now, I did not maintain any regular contact with the father of victim C. To my knowledge, I have never met victim C. I did have a very brief text message exchange when I learned that his daughter passed away, and I extended my condolences to he and his family on a text between myself, him, and my husband. I think it is interesting to note he had to ask who it was on the other end of that text, as my name was not in his contacts. It was a very brief exchange, and nothing else has been exchanged since. It is my opinion that these facts do not require mandatory recusal either under 757.19 of the Wisconsin statutes or Supreme Court Rule 60.04. Of course, all of that applies to me because as a judge, I am bound by those requirements. There are 7 scenarios that are described in the subsections A through G of 757.19 sub 2, which require a judge to disqualify herself from a criminal proceeding. Subsections A through G do not apply with the facts that I've provided or any of the scenarios that are described there, as I won't spend any time going through them. The only question is whether subsection G applies, and if the court determines that for any reason she cannot, or it appears that she cannot act in a fair and impartial manner, the court should recuse. Of course, I've now provided the parties with the facts about my knowledge of the father of victim C and his wife. I would also acknowledge that these are non-exhaustive circumstances, meaning the ones that are specifically enumerated in 757.19 and also in 60.04 sub 4 of the Supreme Court rules. In the comments and other parts of that Supreme Court rule, there are examples of when, for example, a judge should recuse. One of the examples, for example, is when a judge is in the process of negotiating with a law firm for employment, the judge would be required to recuse herself from any manner in which that law firm is appearing before the judge. As I indicated previously, I do believe, and I will be fair and impartial in this case. I hold no bias in favor or against any of the parties here, including Mr. Brooks. A bias or prejudice requiring recusal most often arises from a prior relationship, but may arise from a strong personal feeling about the alleged conduct of the party. Again, I don't have any strong personal feelings about the alleged conduct of the party, meaning Mr. Brooks here. And although I have a prior professional relationship, I do not have a current relationship with the father of victim C or anyone in his family. As I indicated, I have not maintained any regular contact with him since our business professional relationship in 2012 and in 2015. Again, the last professional contact with him was in 2018. I do not believe the extension of condolences to someone that I once knew reflects any bias regarding this case. Again, I maintain an impartial view of the parties and their respective interests in this case. I'd also point out that this court is in a unique position with its prior work experiences, both 4 years with the district attorney's office as an assistant DA, and then 7 years as a criminal defense attorney here in southeastern Wisconsin. And that's only part of my experience. and I've, of course, been on the bench now for 10 years.
I don't think Brooks has one single legitimate reason for appeal, but even if he could use this as a reason, Judge Doro has made it extremely clear that her relationship with the father of victim C simply doesn't meet the requirements for recusal. But another thing that you might remember from Darrell's outburst during the trial was him chastising the judge over her oath, or as he calls it, her oath.
I also took an oath. I've taken that oath now twice. Once when I took the bench, actually 3 times. Once when I was appointed, then when I was elected following that appointment, and then again when I was reelected. That oath states in part, I will support the Constitution of the United States and the Constitution of the state of Wisconsin, that I will administer justice without respect to person and will faithfully and impartially discharge the duties of said office to the best of my ability. So help me God. That is an oath I take incredibly seriously, and I am committed to acting impartially in every case that comes before me. The Supreme Court rules are also very clear that a campaign contribution does not affect the court's ability to be fair and impartial. It is not a situation that requires mandatory recusal. I'd also point out that I was elected not once but twice by the people of Waukesha County to hear cases such as this. And I believe I was elected because I do have a reputation to be fair and impartial. Of course, my subjective analysis is only part of the analysis. There should be an objective analysis as well. I would also note, again, in addition to the oath that I've just taken and my responsibility as a judge elected by the citizens of Waukesha County, that a judge is also presumed to be free of bias or prejudice. And I am quoting from State versus Santana. That's 220 West 2nd, 674, a Court of Appeals case from 1998. There are many other cases that discuss recusal that I have reviewed as well. I do not intend to go through them here today, but I have reviewed them. And what I can tell you is I have not found a situation such as this. Some of those cases talk about campaign contributions. Others talk about the relationship or some type of knowledge or statement and things of that nature. In this case, it is my constitutional, it is my ethical responsibility to preside over the cases that are assigned to me. That is also from the Supreme Court rules, also found in 60.04 sub 4. And so because of all of that, and despite the disclosures that I have identified here today, I am going to remain on this case and not recuse myself, as I do not see it is required under either the statute or the Supreme Court rule.
And good luck finding any Waukesha judge who isn't somehow tied to another victim in this case. I mean, Darrell Brooks hit 70 to 100 people with his car at a Christmas parade. Besides, this guy didn't even think people should be allowed to watch the news before testifying. None of these things matter when you're caught on camera, smiling and laughing while you're running your car over innocent people. So anyway, this entire live stream from March of 2022 is under 40 minutes long. And the rest of it is mostly about scheduling and how long the trial will take. And we're not going to rehash everything from the pretrial for 2 reasons. The first is I just want to go over the parts I think are interesting. And the second reason is portions of the pretrial are actually pretty hard to find. And I've searched and I just don't think I've found them all. But I did find some footage that I hadn't previously seen. It comes from the first half of the hearing that was held on August 26th of 2022. I was unable to find the second half. But during this footage that I did find, they discuss whether or not the interrogation footage will be shown, Brooks' supposed injury during his arrest, and they talk about the things that were found underneath Brooks' mattress after the search of his cell. And it eventually gets pointed out that Brooks is asleep or pretending to be asleep during this entire hearing.
Just briefly, Judge, I observed that for about the past 40 minutes, Mr. Brooks appears to be asleep in the courtroom. I don't know if he's just being disrespectful, uninterested, or if he's not feeling well. But to avoid a appellate issue in the future, I think it'd be appropriate to inquire if he is capable of assisting in his own defense at this point.
All right, why don't I give the defense attorneys a moment? We'll mute the microphone so they can talk to Mr. Brooks, make sure he's feeling okay, and make an assessment of his ability to assist in his defense during these proceedings. I'll step off while we do that.
All right, and we're going to take a break, and then we'll pick this up when we return.
Why don't we do that? That's
Okay.
probably best. I will mute the audio. The live stream will keep going unless the defense wants me to stop it. At this
All
point.
right, please.
Thank you.
So you can plainly see that Brooks is visibly upset about being called out for this. But of course, they immediately go to break and Doro mutes the audio. So we can't hear what Brooks is saying if he's saying anything at all, and the deputies promptly remove him for about 20 minutes. And during that 20 minutes, you can actually see the defense attorneys sitting there together, smiling and laughing, and generally enjoying life. But their smiles immediately fade away as soon as Brooks is brought back into the room. And as they try to explain to him the things that were discussed while he was sleeping, you can see him quickly spiral out of control. He's getting more and more angry as the seconds tick by. And unfortunately, we still can't hear what he's saying. But as soon as Judge Doro enters the room, the audio comes back. And what we're about to see is the very first of his outbursts on camera that I can find.
Mr. Brooks, the live stream is on.
I don't care about no live stream, just like y'all don't care. All this political, this the show. Y'all to put y'all getting told what to do.
Mr.
Y'all
Brooks.
getting paid what to do.
Mr. Brooks, look at me for a minute. Mr. Brooks. Mr.
You
Brooks,
sit
look
up
at
here and act like you know me. People like you don't, y'all
Mr.
you don't know
Brooks.
nothing about where I come from.
Mr. Brooks.
You push me, dog.
Don't push that then.
Mr. Brooks.
Don't push that.
Push me again.
You want
Mr. Brooks, we have to continue with this hearing.
to talk to the judge or not?
No, I'm worried about, man, don't put your hand on me, dude.
Nobody put their hands on you.
Yeah, they better not put their hand on me.
That may sound like a threat, but we all know what he's going to do if someone puts their hands on him. The same thing he always does. Claim to be injured to garner sympathy.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about...
Don't touch me, dog. Can't see that.
All right, we're going to take a break and we're going to come back after lunch. I'm not going to do this with him right now. He needs to be here. He's not cooperating. I'm going to give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Get your hands off me.
We'll come back at 12:30.
Just told him to get up off me.
12:30, everyone.
Thank you, Judge.
Darrell Brooks complained multiple times throughout the jury trial that he was being manhandled by the deputies.
Y'all are brutalizing me.
So it's very possible this might be something that he includes in his appeal. I also think he's going to dig into that relationship that Judge Doro had with the father of victim C, and of course the fact that he donated to her campaign. Basically any fact about this trial that Brooks sees as a weakness, he's going to try to exploit it. I just don't think there's a single one that's viable. But as I think back to the things that happened during the jury trial, my best guess is Brooks is going to look through the entire transcript of that trial. And he's going to meticulously pick out every single thing that happened that he didn't agree with. Every time an objection was sustained against him, every time his objections were overruled, each time that he was removed to another courtroom to watch on a monitor, he'll bring up the argument that the prosecution was coaching the witnesses again. He'll probably even bring up the supposed recall of the Ford Escape that his mother received in the mail years ago and did nothing about. There's just no telling what kind of brain constipation he's going to put in that appeal. All I can do is speculate. And if you have a theory on what you think Darrell Brooks might use as the basis for his appeal, I want to hear it, so leave it in the comments below. And I know this video isn't very long, but I'm going to end it here anyway, because I went through hours and hours of videos just to find this footage. And it seems like a good stopping point because the next part of the trial begins the conversation about going pro se, or pro per, depending on your level of brain constipation. Anyway, thanks again for watching, and I'll be back soon.